This is a screenshot video in the contracts course, and we're dealing now with the topic of genuineness of assent. And we're assuming that we have in place the four requirements for a valid contract that we've been talking about these last few weeks. So we're assuming we have an agreement, we're assuming we have consideration, we're assuming that we have capacity and legality. And this area or topic of genuineness of assent explores the general question, is there something wrong about the agreement itself? In other words, that part of or that requirement of a valid contract, is there something wrong with the agreement that's going to give a party to the agreement the ability to rescind the agreement, to make the agreement, in other words, voidable, if you will, to get out from underneath the contract. And there's different topics that we'll be talking about in this area: mistake of fact, fraud, undue influence, duress, and something known as unconscionability. Our first area that we're going to explore is mistake of fact. In other words, the setup here is that parties have entered into an agreement and one or both of them is mistaken about some significant fact concerning the subject matter of the agreement. And when we look at mistake of fact, we first have to distinguish between fact and value. As I know, philosophically, one might make the argument that assessments of value is just another fact, but in the law of contracts in this area, we make that distinction. And so an example I have, and I think it's a good one, let's assume I have a painting that I've inherited, just handed down in the family. And it could be that painting was created, if you will, by a famous artist that I simply never heard of, because I'm not really that knowledgeable about art. I think Noah, if it said the painting was from Picasso or Jackson Pollock, that would be a famous painter. But there's quite frankly a lot of painters that people knowledgeable in art will know about that I don't. So the setup is I have this painting that's from a famous painter. I know in fact what the painting is because there it is. It's got the artist's name on it, and there's the painting. A mistake I might be making is the value of the painting, simply because I'm unaware that the artist is famous, and I sell the painting, let's say at a yard sale, for $50, when in fact the painting is worth $50,000. That would be considered a mistake of fact. That would be considered a mistake of value and not a mistake of fact, and I wouldn't be in a position to rescind the agreement. So we're looking at a situation where we don't have a mistake of value, we have a mistake of fact. And by the way, I apologize. I try to do these videos when I'm by myself in my law office on a Sunday, to be honest with you. That just gives me a period of time where I don't get distractions, except, of course, when my phone is blowing up, as it's been today, so I apologize. But we're focusing now on an agreement where we have a mistake of fact. And this is an example in the book, but we can certainly talk about it without the book. And what happens is a person is injured in a car accident, and there's an uninsured motorist, so this person is fortunate enough to be able to bring his claim for damages against his own insurance company. It's a feature that a lot of liability policies have. And so he's in discussions with his insurance company about how much money he will be entitled to, and for some reason he doesn't secure the services of an attorney. He's doing it himself, and he believes that the policy limit is far lower than it actually is. And so, and he tells the insurance company, I don't have the policy, and this is what the policy limit is, and I'll settle for this amount of money. And the insurance company, for whatever reason, and it could have, I don't think it was an attempt to rip this person off, but the insurance company was careless and didn't realize apparently that the fellow who didn't have his policy thought that the policy limit, meaning that the claim couldn't be paid over a certain amount, agreed to settle for this amount. And then after the settlement, or if you will, the contract was reached, the fellow who was injured discovered that the policy limit was far higher than he realized, and he went into court to rescind the agreement. By now, of course, he has a lawyer, and the court permitted him to rescind the agreement because of the mistake of fact. And our rule is, if the mistake of fact was unilateral, meaning made by only one party, and this would have been the case here, then the party making the mistake can rescind the contract, but only if the other party who didn't make the mistake knew or had reason to know of the mistake. And in this situation, even if the insurance company representative did not know of the mistake, certainly had reason to know of the mistake because the insurance company, of course, had in its possession the policy. So the unilateral mistake can support a rescission, but only if the other party knew or had reason to know. But this is a good example of that. If there is a mutual mistake of fact, and that is all parties, or if it's a two-person or two-entity contract, both parties know of the mistake, then either party can rescind the contract. And there's a case in the book that, again, I know you don't have right now, but it's a good example of a mutual mistake of fact where a seller and buyer of cotton were mistaken about the ship that was going to be used to transport the cotton, because there was two different ships with the same name, and one of the parties then was allowed to rescind the contract. We don't, it's been my experience in the practice of law, we don't run into a lot of mistake of fact situations, but at least, again, we know the rule. If one party makes the mistake, it's called unilateral, and that party can rescind if the other party knew or had reason to know. And if it's mutual, either party can rescind. But again, I would point out, and I'll jump up the page, it has to be a mistake of fact and not a mistake of value. What we're going to get into next is another problem that we run into with the so-called genuineness of assent, and that is fraud. And the setup for fraud is that one party has been, if you will, fraudulently induced to enter into a contract by the other party. And our definition for fraud in this context can be broken down into three parts. First, there must be a misrepresentation of a material, or if you will, significant fact. And the misrepresentation has to be made with the intent to deceive, and typically we would establish intent to deceive circumstantially by showing that the party who made the misrepresentation knew that it was false. And then lastly, there has to be a justifiable reliance on the misrepresentation by the other party. And justifiable means reasonable. I point out that fraud in the law is a tort and a way to rescind a contract. So where a party has been fraudulently induced to enter into a contract, they have the ability to rescind the contract, and if they've been damaged, they can bring a tort action to recover for their damages. If we look at these three parts of the definition, we see that in fraud, there's a distinction between fact and opinion. So if someone simply offers an opinion in the form of a representation, and I say, for example, if I'm a car salesperson and I say this car is a cool car, or in my opinion, you'll be popular because you're going to be owning it, that's a misrepresentation of opinion, and typically that cannot be a basis of fraud. There's an exception, however, to the fact-opinion distinction, and that is if the opinion is made by a party who claims superior knowledge, in which case the courts will treat it as a misrepresentation of fact. And a classic example, and again, it was mentioned in the book, but we can certainly talk about it without the book, and it's the case involving the Arthur Murray dance studio. A woman came to the studio and purchased thousands of dollars worth of lessons. Her claim was that when she was given the lessons over the course of time, she was always told she had great dance potential, that her dancing was improving, and in fact, her claim was she was a terrible dancer, she wasn't improving, and she had been fleeced for these thousands of dollars. So she sues the dance studio for to rescind the contract, but also to recover damages for fraud. And the dance studio defends on the ground that she was using as the misrepresentations made to her misstatements of opinion rather than misstatements of fact. But the court used the exception that we just identified, which is if an opinion is made by a party claiming superior knowledge, and in this case certainly the dance studio had superior knowledge about this woman's dancing potential and how she was coming along with her lessons, then the courts will treat, as they did in this case, the statements of opinion as statements of fact. And what had happened was the lower court in Florida had thrown out the lawsuit, and the appeals court said the lawsuit could proceed because the plaintiff who had purchased the dancing lessons had stated a valid claim in fraud. And then I don't know how the case eventually came out. I suspect it was settled. But that is our distinction between fact and opinion, but where we have the exception if the, again, opinion is stated by a person claiming superior knowledge. I'm going to stop this video at this point, and then we'll pick up when we look at different types of misrepresentations.